Justice Thomas delivered the opinion of the court in Unitherm Food Systems, Inc. versus Swift-Eckrich, Inc. Ordinarily, a party in a civil jury trial that believes the evidence is legally insufficient to support an adverse jury verdict will seek a judgment as a matter of law by filing a motion pursuant to Federal Rule of Civil Procedure 50A for submission of the case to the jury. And then, if the Rule 50A motion is not granted and the jury subsequently decides against the party, a motion pursuant to Rule 50B, period. In this case, however, the respondent filed a Rule 50A motion before the verdict, but did not file a Rule 50B motion after the verdict, nor did respondent request a new trial under Rule 59. The Court of Appeals nevertheless proceeded to review this upon a finding that the evidence was insufficient, remanded the case for a new trial. Because our cases addressing the requirements of Rule 50 compel a contrary result, we reverse. So that is SCOTUS reversing the appeal court's reversal of the verdict. Reverse. So the verdict, I'm not really sure who is against yet. Part 1 of this opinion. The genesis of the underlying litigation in this case was ConAgra's attempt to enforce its patent for a method for browning pre-cooked whole muscle meat products, U.S. patent, blah, blah, blah. In early 2000, ConAgra issued a general warning company sold equipment and processes for browning pre-cooked meats, explaining that it intended to aggressively protect all of its rights under the patent. Petitioner Unitherm sold such processes, but did not receive ConAgra's warning. ConAgra also contacted its direct competitors in the pre-cooked meat business, announcing that it was making the patent and corresponding patents that may issue available for licensure. Jenny O, a direct competitor, received ConAgra's correspondence and undertook an investigation to determine its rights and responsibilities with regard to the 27 patent. Jenny O, the browning process it had purchased from Unitherm was the same as the process described in the patent. Jenny O further determined that the patent was invalid because Unitherm's president had invented the process described in the patent 6 years before ConAgra filed its patent application. Consistent with these determinations, Jenny O and Unitherm jointly sued ConAgra in the Western District of Oklahoma. As relevant here, Jenny O and Unitherm sought a declaration that the patent was invalid and unenforceable, and alleged that ConAgra had violated Section 2 of the Sherman Act, 15 U.S.C. Section 2, by attempting to enforce a patent that was obtained by committing fraud on the Patent Trademark Office. See Walker Process Equipment, Inc., Food, Machinery, and Chemical Corp. The district court construed the 27th patent and determined that it was invalid based on Unitherm's prior public use and sale of the process described therein. 35 U.S.C. Section 102B, period. After dismissing Jenny O for lack of standing, the district court allowed Unitherm's antitrust claim to proceed to trial. Prior to the court's submission of the case to the jury, ConAgra moved for a directed verdict under Rule 50A based on the legal insufficiency of the evidence. The district court denied the motion. The jury returned a verdict for Unitherm, and ConAgra neither renewed its motion for judgment as a matter of law pursuant to Rule 50B, nor moved for a new trial on antitrust liability pursuant to Rule. On appeal to the federal court, ConAgra maintained that there was insufficient evidence to sustain the jury's antitrust verdict. Although the Federal Circuit has concluded that a party's failure to present the district court with A post-verdict motion precludes appellate review on sufficiency of the evidence. So that I didn't really know that. Where did that come from? The federal court has concluded. In the instant case, it was bound to apply the law of the 10th Circuit. Under the 10th Circuit law, a party that has failed to file a post-verdict motion challenging the sufficiency of the evidence may nonetheless raise such a claim on appeal so long as the party for the submission of the case to the jury. And that came from Cummings versus General Motors Court. Notably, oh my goodness, I have a headache. Notably, the only available relief in such a circumstance is a new trial. Free to examine the sufficiency of the evidence, the Federal Circuit concluded that although Unitherm had presented sufficient evidence to support a determination that Conagra had attempted to enforce a patent that it had obtained through fraud on the PTO, the Patent Trademark Office, Unitherm had failed to present evidence sufficient to support the remaining elements of its antitrust claim. Accordingly, it vacated the jury's judgment in favor of Unitherm and remanded for a new trial. We granted certiorari and now reverse. So I think that's the holding of it's actually the conclusion of the appeal court. Federal Rule of Civil Procedure 50 sets forth the procedural requirement of the evidence in a civil trial, jury trial, and establishes 2 stages for such challenges. Prior to submission of the case to the jury and after the verdict of entry of judgment, Rule 50A allows a party to challenge the sufficiency of the evidence prior to submission of the case to the jury and authorizes the district court to grant such motions in the court's discretion. At the court's discretion. Rule 50B, by contrast, sets forth the procedural requirements for renewing a sufficiency of the evidence challenge after the jury verdict and entry of judgment. The court does file a post-verdict motion under Rule 50B on several occasions and in a variety of procedural contexts. This court has concluded that in the absence of such a motion, an appellate court is without power to direct the district court to enter judgment contrary to the one it had permitted to stand. Similarly concluded that a party's failure to file a Rule 50B motion deprives the appellate court of the power to order the entry of judgment in favor of the party where the district court directed the jury verdict, and where the district court and then deny the motion after the verdict was returned. A post-verdict motion is necessary because determination of whether a new trial should be granted or a judgment entered under Rule 50B calls for the judgment in the first instance of the judge who saw and heard the witnesses and has the feel of the case, which no. Moreover, I think they'll go to the 7th Amendment here, quoting, requirement of a timely application for judgment after verdict is not idle motion because it is an essential part of the rule firmly grounded in principles of fairness. The foregoing authorities lead us to reverse the judgment below. Respondent correctly points out that these authorities address whether an appellate court can enter a judgment in the absence of a post-verdict motion, as opposed to whether an appellate court may order a new trial as the Federal Circuit did here. But this distinction is immaterial. This court's observations about the necessity of a post-verdict motion under Rule 50B and the benefits of the district court's input at that stage apply with equal force whether a party is seeking judgment as a matter of law, hone this trial and entering judgment. Its appraisal of the bona fides of the claims asserted by the litigants is of great value in reaching a conclusion as to whether a new trial should be granted. Similarly, this court has determined that a party may only pursue on appeal a particular avenue of relief available under Rule 50B, namely the entry of judgment or a new trial, when that party has complied with the rules filing requirements by requesting that particular relief below. Despite the straightforward language employed by Cone, Globe Liquor versus San Roman, and Johnson versus New York, these are 1948 and 1952 respectively, respondent maintains that those cases dictate affirmance here because in each of those cases, litigants secured a new trial, but in each of those cases, the appellants moved for a new trial post-verdict in the district court and did not seek that. Respondent was only entitled to a new trial by virtue of its motion for such within the time required by Rule 50B. Accordingly, these outcomes merely underscore our holding today. The party is not entitled to pursue, this is the holding, a new trial on appeal unless the party makes an appropriate post-verdict motion in the district court. Or in the case of Johnson, as we heard, within that same time frame, which was 28-day time frame required by the Federal Rule of Civil Procedure 50B, as in Johnson. Our determination that respondent's failure to comply with Rule 50B forecloses this challenge to the sufficiency of the evidence is further validated by the purported basis of respondent's appeal, namely the district court's denial of respondent's post-verdict Rule 50A motion. As an initial matter, Cone, Globe Liquor, and Johnson unequivocally established that the precise subject matter of the party's Rule 50A motion, namely its entitlement to judgment as a matter of law, cannot be appealed unless that motion is renewed pursuant to Rule 50B. Here, respondent does not seek to pursue on appeal the precise claim it raised in its 50A motion before the district court, namely its entitlement to judge. Rule 50A motion, i.e. the entry of judgment, then surely respondent is foreclosed from seeking a new trial. Relief it did not and could not seek in its post-verdict motion. In short, respondent never sought a new trial before the district court and thus forfeited its right to do so on appeal. The text of Rule 50B confirms that respondent pre-verdict Rule 50A motion did not present the district court with the option of ordering a new trial. That text provides that a district court may only order a new trial on the basis of issues raised in a pre-verdict 50A motion when ruling on a renewed motion under Rule 50B. Accordingly, even if the district court was inclined to grant a new trial on the basis of arguments raised in respondent's pre-verdict motion, it was whether to do so under Rule 50B absent a post-verdict motion pursuant to that rule. Consequently, the Court of Appeals was similarly powerless. Similarly, the text and application of Rule 50A support our determination that respondent may not challenge the sufficiency of the evidence on appeal on the basis of the district court's denial of Rule 50A motion. The rule provides that this court may determine that there is no legally sufficient evidentiary basis for the reasonable jury to find for a party on a given issue and may grant a motion for judgment as a matter of law against that party, emphasis added. Thus, while a district court is permitted to enter a judgment as a matter of law when evidence is legally insufficient, it is not required to do so. To the contrary, the district courts are, if anything, encouraged to submit the case to the jury rather than granting such motions. Thus, the district court's denial of respondent's post-verdict motion formed the basis of respondent's appeal because the denial of that motion was not error. It was merely an exercise of the district court's discretion in accordance with the text of the rule and the accepted practice of permitting the jury to make an initial judgment about the insufficiency of the evidence. The only error here was counsel's failure to file a post-verdict motion pursuant to Rule 50B. For the foregoing reasons, we hold that since respondent failed to renew its post-verdict motion as specified in Rule 50B, there was no basis for review of respondent's sufficiency of the evidence challenged in the Court of Appeals. The judgment of the Court of Appeals is reversed. It is so ordered. Now, Justice Stevens, with whom Justice Kennedy joins dissent. For the next, it's only 2 pages, not very long. Murphy's Law applies to trial lawyers as well as pilots. Even an expert will occasionally blunder. For that reason, Congress has preserved the Federal Appeals Court's power to correct plain error. Even though trial counsel's omission will ordinarily give rise to a binding waiver, this is not a case, in my view, in which the authority of the appellate court is limited by an explicit statute or controlling rule. The spirit of the Federal Rules of Civil Procedure favors preservation of the court's power to avoid manifestly unjust results in exceptional cases. Moreover, we have an overriding duty to obey statutory commands that unambiguously express the intent of Congress, primarily on a case decided in 1947, Cone v. West Virginia Pulp and Paper Company, and a case decided in January 1948, Globe Liquor Company v. San Roman. The court holds that the Court of Appeals was powerless to review the sufficiency of evidence supporting the verdict in petitioner's favor because the respondent failed to file proper post-verdict motions pursuant to Rules 50B and 59 of the Federal Civil Procedure in the trial court. The majority's holding is inconsistent with the statute enacted just months after Globe Liquor was decided. That statute, which remains in effect today, provides the Supreme Court and any other court of appellate jurisdiction may affirm, modify, vacate, or set aside or reverse a judgment, decree, or order of a court lawfully brought before it for review, and may remand the case and direct the entry of such appropriate judgment, decree, or order, or require such further proceedings to be had as may be just under the circumstances. And nothing in Rule 50B, that's actually Title 28 of the United States Code, Section 2106. Noting in Rule 50B limits the statutory grant of power to appellate courts, while a party's failure to make a Rule 50B motion precludes a district court from directing a verdict in that party's favor. The rule does not purport to strip the courts of appeals of the authority to review district court judgments or to order such relief be just under the circumstances, nor do general principles of waiver or forfeiture have that effect. It is well settled that a litigant's waiver or forfeiture of an argument does not, in the absence of a contrary statutory command, preclude the courts of appeals from considering those arguments. Arguments raised for the first time on appeal may be entertained, for example, if their consideration would prevent manifest injustice. For the reasons articulated by the court in Cone, it may be unfair or even an abuse of discretion for a court of appeals to direct a verdict in favor of the party below if that party failed to make a timely 50B motion. Likewise, it may not be just under circumstances for a court of appeals to order a new trial in the absence of a proper Rule 59 motion. Finally, a court of appeals has discretion to rebuff on grounds of waiver or forfeiture a challenge to the sufficiency of the evidence absent a proper Rule 50B or Rule 59 motion made in the district court. None of the foregoing propositions rest, however, on determination that the courts of appeal lacks power to review the sufficiency of the evidence and order appropriate relief under these circumstances, and I can divine no basis for that determination. I respectfully consent.